We are headed into what will be a very, very fruitful discussion between two rock stars delivering what could result in you passing the Juvenile Law Board certification as it did for me. We have our next session is a discussion about best practices for the collaborative efforts between defense and prosecution of children who are referred to juvenile court, as well as strategies for using evidence of mental health and intellectual and developmental disabilities in juvenile delinquency cases and trials. Our speakers today are Kameron Johnson and Riley Shaw. Kameron Johnson is the juvenile public defender for Travis County, Austin, Texas. Kameron Johnson received his law degree from the University of Texas School of Law and is licensed to practice in both federal and state courts. He is board certified by the Texas Board of Legal Specialization in both criminal law and juvenile law. He is also a former adjunct professor at the University of Texas School of Law, where he has taught juvenile law and trial and appellate advocacy. We also have another rock star, Riley Shaw, has worked as an assistant criminal district attorney with the Tarrant County Criminal District Attorney's Office for the past 23 years. Mr. Shaw served for many years as chief of the juvenile unit and currently serves as deputy chief over the criminal division in addition to his duties as a criminal prosecutor. Mr. Shaw serves as a board member of the Texas Violent Gang Task Force and has previously served as a member of the Texas Juvenile Justice Board and as chairman of the Juvenile Law Section of the State Bar of Texas. Mr. Shaw is also board certified in juvenile law. Welcome to our panel.
Thank you. We are very happy to be here with you today. And my name is Riley. This is Kameron. It's funny, so Kameron and I were talking beforehand. We first got to know each other 15 years ago when TYC kind of blew up, if y'all remember that. And we spent literally hundreds of hours with the legislature that spring working on efforts to legislatively reform back then what was called the Texas Youth Commission. And it was a very interesting and difficult time, and we came at it from two very different perspectives, but we found so much common ground through that process. We're both very happy to be with you here today. I want to kind of mention a few of the speakers that you've seen over the last 2 days, and I want you to think about what they told you and how it might apply in the things we talk about today. So Dr. Lepore talked about trauma and brain development and family dynamics. Ms. Toon, who's in here, gave the perspective on her life experience, both as a person in the system and as a person who's gone through basically the family dynamics that she grew up in. Dr. Almeida talked about ACEs, and I want you to think about all of those things as we kind of go through our presentations. First of all, and this may seem obvious, but juvenile justice is different. It is different from criminal justice. Children are not adults. Age matters, brain development matters, and family dynamics matter. All of those things have an impact. As kind of an old prosecutor, I'm very conservative in the way that I review law, and I'm very conservative in the way that I apply it. So the first thing I do, the most important thing to me, is what did the legislature tell us that they want the law to be? And did they give us a reason why they want it to be that way? And so for those of you who practice in the juvenile realm, if you read Title III of the Texas Family Code, that is what the legislature enacted as a juvenile justice code, and they gave us a very specific roadmap at the beginning of that statute. I want to go through that roadmap with you. I'm taking us some extra time, but this is also going to help out with Kameron's. The very first section of Title III of the Family Code, it begins with Section 5101. And the legislature tells us that children are different and the system is different. It starts off sounding very much like criminal justice. The first thing they tell us is the purpose of this code is to provide for the protection of the public and public safety. Sounds very criminal justice. Also says consistent with the protection of the public and public safety to promote the concept of punishment for criminal acts. Remember, this is the Juvenile Justice Code. Also sounds very criminal, right? And things start to change almost immediately. There are only 6 sections of this. In the middle of the second one, it says to remove the taint of criminality from children who commit certain unlawful acts. That's the first place where we say, the legislature's telling us, we expect this to be different. We expect you to look at it differently. The next thing they say is they want us, all of us, prosecution, defense, judges, provide treatment, training, and rehabilitation that emphasizes accountability and responsibility for both the parent and the child for the child's conduct. We're immediately talking about family dynamics. The legislature is talking about family dynamics. The next section, when we go over to 3 through 6, you're going to see some more differences between the juvenile justice system and the adult criminal justice system. The legislature tells us they want this system to provide for the care of children, for the protection of children, for the wholesome moral, mental, and physical development of children. Doesn't that sound kind of amazing? Does that sound like the criminal justice system? Does that sound like you need to have a little shift? Next section, provide for the welfare of the community and to control the commission of unlawful acts by children. Now we're back to criminal justice, but I want you to think back to yesterday to Dr. Lepore and his 4 pillars. Loving children, giving them boundaries. Number 5 begins in the first sentence with the words, in a family environment. It doesn't sound like sending kids to jail as a first thought. Achieve the foregoing purposes in a family environment whenever possible, separating the child from the child's parents only when necessary for that child's welfare or in the interest of public safety. And when a child is removed, we're supposed to provide them with the care that they should be provided by parents. It's a very, very different outlook. And this is coming from the legislature. Also, to provide a simple judicial procedure that ensures a fair hearing and a child's constitutional and other legal rights. Now, this last section, I think, is probably as a result of many of the cases that came out in the late 60s. Before then, the juvenile justice system was pretty loosey-goosey, and kids' rights were not really thought of that much. There were a couple of cases that came out in the 1960s that tell us that children also have rights. So a child in the juvenile system is entitled to due process and to representation by counsel. That's under the Kent case. Under the In re Galt case, children are entitled to notice, to confrontation of the witnesses, to representation by counsel and appointed counsel, and they have a privilege against self-incrimination. So generally, if you look at the rest of the cases that came after these, the constitutional protections that an adult has, a child also has. So we're here to help kids. We're also here to protect their rights. So as a prosecutor, I think about that first section of the Family Code and the 6 bullet points it gave us. And I try and think about it throughout the various processes of a juvenile case. One of the places that it impacts is pretrial publicity. If we're supposed to remove the taint of criminality of children who've engaged in certain unlawful criminal acts, we probably need to be real mindful of what we put out there in the press. Should you be using a child's name in the press? Should you be putting their photo out there? In the internet age, does any of that ever go away? It doesn't. You've got to be real careful talking about the nature of the allegations. Many of the cases that we hear in juvenile court are offenses within the family. And when we put those facts out there, those facts can have negative impacts on that family. Parents can lose jobs. Families can lose housing. So you got to be careful about what you put out there. We had some unique circumstances during the pandemic, and there were video hearings. I think most of those video hearings have stopped now, and the concern that many had with those hearings is the permanency of that data being out there. So anytime there is a juvenile video hearing, just like a juvenile press conference, you have to be very, very mindful of perhaps not using a child's name, not having that child's face on the video. Those things matter. You'll see I wrote down at the end, bottom here, siblings or parents as victims, and I alluded to this a little bit. And this is something I never really thought about until I got deeper into doing juvenile work. Many of the sexual offenses that make it to juvenile court are offenses within the family. They are sibling on sibling. And if that information gets out there, let's say, for instance, a child has to register as a sex offender, you have to be very thoughtful as a prosecutor in deciding whether or not you want to seek sex offender registration for a child, particularly in those circumstances. Because the victim lives in that child's home and may well go to that child's school. So as soon as you register that child as a sex offender, everyone at school knows that the victim who also goes there has had something done to them by their sibling. If there is a sex offender in the family household, even if they're 12 years old, that may violate the terms of the apartment lease, and the entire family may end up homeless because of a sex offender registration. So those are things that you really have to be mindful of in evaluating what is the right direction to go as a prosecutor. None of this, I'm not telling you that there's never a time to register a kid as a sex offender. That kid is out there, but you have to be very, very mindful. There can be no knee-jerk reactions, and you have to think about it differently than you would in an adult situation. An adult can just go seek to get another apartment. A 12-year-old can't go seek to get a new apartment. They're just stuck. They don't get to choose not to go to their school. They're stuck. So it is important to think about those issues when making decisions, if you're going to do so ethically. Let's see. I've heard talk over the last 2 days about the crossover between mental health and juvenile justice, and it's in Tarrant County we estimate it's 40 or 50%. But another crossover is also huge, and that is juvenile justice and child welfare. Also seems to be about 40% or so. So we do a lot of work with mental health and child welfare in many juvenile cases. And it's something that you have to be open to and willing to investigate, because you can often leverage those systems, leverage the resources available in those systems to get a better outcome for that child and that family and for the community. Just like I mentioned earlier, you've heard, how am I doing? I'm doing okay on time. 4 minutes? Okay. The age of a child matters deeply. There's a big difference between an 11-year-old who is subject to the juvenile justice system and a 16-year-old. So as between that 11 and 16-year-old, you have to evaluate your case differently as a prosecutor. Also, you have to remember that 16-year-old's not a 35-year-old committing the same offense. So it's layers of difference. Psychological evaluations and diagnoses are important in determining what is the best path forward, because ultimately every child is coming home because they're children. We don't lock anyone up for life who's a child, so they're all coming home. If you ever take them out of their home, we'd better make sure that they're in a position. I want every kid who touches the juvenile justice system to leave better than they were when they got there. I want the neighborhood in which they live to be happy to see them come home. And I want them to be happy and have a productive life. And our best opportunity for that is intervening when they're children. Oftentimes, as a prosecutor, we have to recognize and tackle mental health issues inside that child's house that may or may not even be that child. Could be the parent, could be a sibling, but those things can cause trauma and stress. And we have to educate that family on how to deal with those issues, either with the adults or for the children. Because of all of these things, it is of the utmost importance that prosecution, the defense, the local juvenile services department, CPS, and MHMR work together. And we try and do that in Tarrant County. I know they try and do that in Travis County and do a pretty good job of it. But we can always do better. A full investigation is so important. I don't know what to do. I can't truly know what to do with the case if I don't have all the information, and neither can the defense and neither can the court. So without good information, everybody loses. And it takes the parties working together to develop that good information, because each party has a different piece of it. And we've got to trust each other and use that information to come to whatever the best result is. It could be, that best result may not sound great every time. And it doesn't mean, it's not about being soft on crime. It's not about coddling children. It's about doing the right thing so that in the long run, that child in our community are in the best position they can be for a life. I'm going to go fast because I've got my 1 minute. We haven't, Cameron, would you talk a little bit about determinate sentencing and certification in yours? Determinate sentencing is a way in which a sentence can go much longer, up to 40 years. Certification means a child being tried as an adult. All of this information we've been talking about is of paramount importance in making decisions as a prosecutor about whether or not to seek a determinate sentence or to ask a judge to waive juvenile court jurisdiction and have a child tried as an adult. And it is so important that we all work together to make the best decision. The decision may still be determinate sentence, it may still be certification, but you can't make a good decision and the decision that long term is right for that child and for the victim of the offense and for your community if all parties don't have full information and work together to do the best. We've got some more to come, but I'm going to turn it over to Kameron now for his part of the stand-up presentation. Thank you.
Thank you, Riley. And good afternoon. Good afternoon. Okay, all right, show me some love. It's like, yeah, okay. Thank you, because I'm always honored every opportunity I get to being able to talk to practitioners. And I am really, really grateful, not only to be here and to talk about juvenile and mental health, but also to give a defense perspective, because that is something that I have been doing for the last 30 years. And the one thing that I wanted to start with is that, you know, we have a branding issue in juvenile justice. When we look at our juvenile population in Texas, what we see is that it has been everly increasing over the years. But when we look at our juvenile referrals, what we'll see is that we have been having a decrease in the number of referrals, the number of youth that have been coming into our juvenile justice system. But it doesn't seem like that in this era. You know, Riley talked about how, you know, back in, I believe, 2007, when we were really doing some work, you know, from the legislature, because the system was in a crisis. And here we are, you know, 15 years later, we're talking about some of the same things. And I think about the days when it really was easy. And it was easy because that we had the protector, we had who we called, you know, Professor Dawson. Professor Dawson, for those of us OGs who remember him, he made it easy for us is because he wrote the family code. He defined what juvenile justice was from a legislative standpoint. When he went to the legislature, everybody listened to him. And he was always looking out for the children's best interests. and we did things differently in Texas. But I've seen a change over that. Riley talked about how we talked about the purpose of the juvenile justice system. I think about when Professor Dawson wrote the family code and he wrote the juvenile justice code, when he talks about to provide for the care and the protection on the wholesome, moral, and mental, this was the number one goal of the juvenile justice system. And then we had a period where things changed. And so this has moved down. It's still important, but it's moved down. You know, when I say that we have a branding problem, one of the things that I like to talk about is that there's a proverb which says that if 5 blind people touched an elephant in different places, they each would have 5 different stories. And that's how I see juvenile justice, because I can think back into that period of the 90s, you know, for those of you remember those super predators? Remember all of those super predators, crack babies, all of those things, and how we had in a period in the 90s where we had the biggest prison expansion, not just in the nation, but in Texas. And we also turned over a bunch of prisons over to the juvenile justice system. And when I say branding, we began to start labeling, you know, who our children were. And we started doing things where prison not only became an option, in many cases, it became a probability for some of our youth. When I say prison, I'm not talking about TJJD or TYC. I'm talking about actual prison. And so in this whole process, like when Riley talked about, you know, determinate sentence and certifications, you know, determinate sentence is where we say, well, we're going to give you a sentence in the juvenile system and give you an opportunity for rehabilitation, for treatment. And if you do well, we're going to keep you in the juvenile system, and then your case could possibly be transferred over to the adult system. And that was something that Professor Dawson created. And it was the first in the nation in Texas when we came up with the determinate sentence. But he created that because at the time there was a movement to actually lower the age where we could try children as adults from 15, some as low as 13. And he came up with the determinate sentence. And what was the result of that? That's the one thing in juvenile justice that Texas does not lead the country in, and that's trying youth as adults. And that's even including our 17-year-olds, that we automatically go into the adult system. So when we look at this process here, we've got to be able to look and see what we're doing and who's doing what. And I want to be able to talk about that, but I want to focus on the role of our defenders. That's me and my colleagues. Because this is a system that it has to include all of the parties: juvenile probation, the district attorneys, prosecutors, judges, criminal defense attorneys. But we have some challenges. We have some challenges. I've been a public defender. This is, you know, going on for probably about 26 years for me, and I'm excited about it because I've enjoyed every day of my work. But sometimes, not sometimes, all the time, I like to think of myself as not just a public defender, but as a constitutional lawyer. But when talking with some of our kids, I want to think about this scene, because this encapsulates what we do.
Wife killing banker. Why'd you do it?
I didn't, since you asked.
You gonna fit right in. Everybody in is innocent. You know that? Hayward, what you in here for?
Didn't do it. Lawyer fucked me.
You know, that's some PG-13 language, but, you know, I hear that a lot. You know, one of the things that I do in my practice is I go out and we provide representations even after disposition. So if a youth is moved out of the home, My office continues to provide representation if they are sent to a placement or if they're committed to TJJD. We still follow and work on them. You know, when I go up to TJJD and some of the different facilities, I have a tendency not only to talk with clients who my office is representing, but I talk with other youth from Austin to see how they're doing, you know, see what is going on. And one of the first things when I talk with them after I introduce myself, I always say exactly is, why are you here? And I usually get those answers that were in that clip. My lawyer didn't say nothing. You know, my lawyer didn't do anything. And I get that consistently, well, except one time. You know, I remember one youth said, and I said, why are you here? He said, $25 million. I was like, wow. It's like, oh, it was a plot to kill his parents and get inheritance for 25. I was like, well, that was different. But I want to be able to talk about some of the things that we've done and some of the things that has happened. Because when we talk about our juvenile justice, we've had an evolution. We've had a period. You know, I want us to go back. We all talk about, you know, Henry Gold. We talk about that. That was in 1967 when the Supreme Court said, hey, you have juvenile justice. But even more importantly, you know, we made a decision. When I say we, I say our Supreme Court, you know, country. It's like, you know what, we're not going to execute youth. And why? Is because we talked about that is that because they're different from adults, the brain development, you know, they're less culpable and the reasons why. Then we later said, you know, we're not going to give them, we can't automatically give them life without parole. Why? It's because they're different. It's because their brain development. You know, some psychologists, I think the best description I've had is say, you know, children are just like, being in a car. You know, they got their brains are like all gas and no brake. You know, and I think about that. And I really, really learned that about 15 years ago when my children got into middle school, and then my whole perspective in life changed. It's because I realized it's like middle school is sort of like where they go through this metamorphosis. You know, things become different. You know, before that, I was Superman. I was superhero. And then it's like, moon, 6th grade, 7th grade comes, and they're looking at me like I'm looking at them, you know, and I'm thinking, why did you do that? And they're looking at me, why did you do that? You know, what are you saying? You know, but we know that. But when we got to being able to deal with these type of situations is like, particularly is that we've got to stop being compartmentalized. When I say we, and I'm talking about not just offenders, but also juvenile probation. What I find is consistent in most places, juvenile probation departments are usually the most constant. Judges may be new to the bench or they may not be, but juvenile probation has been there. You know, prosecutors may come and go, you know, defense attorneys. But there are certain things that we've got to start doing and we got to start looking at. You know, for example, it's like looking at the children individually because certain things happen. For example, we have an overrepresentation, you know, of youth in our system, of males, youth of color, and it's always been like that. Why? And what are we doing about it? Well, let's start with us defenders also being able to step up and being able to be part of this process and being able to look at. I know it gets difficulty when we talk about bringing up issues of race, but it's important is because there are different outcomes. There are different things that happen. We've got to start looking at how we're being able to do that. We got to start looking at those things we talked about earlier, childhood trauma. It makes a difference. You know, I'm not going to ask, but I want you to think about it is if somebody has been arrested, do you think about that as a positive or a negative experience? All of our youth that come into the system, that is frightening, you know, process. To be in detention. Think about very quickly the top 10 things that's important to you in your life. Now think about the top 10 things that are important to a youth or a child. And what happens when they go into detention? We take every single one of them away. Every single one of them. Their clothes, their shoes, their Jordans, their friends, their music, their computers, and their telephones. I think that, man, that is different. But when we look at the youth, what we have is, and I'm talking about that disproportionality, those are the things that we got to start addressing. And we got to start looking at that, looking at the trauma, looking at the race and how it impacts our different youth and all of our youth, and looking at their mental health. And started from the beginning of the process. Probation, you do a great job when kids come into the system. You give them these assessments, you being able to do that. But how many of us share that with not just the defense attorneys, the prosecutors, some of them are just confidential. It's important in how we being able to represent them. When I say we've got a branding problem, we're going to change the game, with your help. As far as defendants, we're going to start being that Atticus Finch. We're going to start having that role where we walk into the courtroom and everybody stands up because we're doing a good job, because we're advocating for these youth. And that's what we need to start doing. And so what we're going to do is we're going to talk about some of the scenarios, and I'm going to give a disclaimer and say that these are not really actual cases, and the names have been changed to protect the innocence. But we're going to talk a little bit about some of the cases that we've been talking about. Like, for example, one of the first cases that I wanted to being able to talk about is that picture, we have a youth. I'm going to call them a dual status youth, and essentially is that they are involved in the CPS system and they're involved in the juvenile justice system. And this was a case where I received a call from a judge in my county in Austin. The child was having a case in another county, and the CPS worker had some concerns, is because the defense attorney said that, well, we have an agreement to being able to work out the case. So just bring your child here about 30 minutes before the hearing, and we'll be able to take care of it. Well, the concern was that this child had a 52 IQ and was in CPS custody and was constantly being moved around and had other challenges. So what do we do? What do we do? Well, I know what the judge did. The judge called me, and, I got in my car. I had to drive up on, a few hours' notice and went up to the court and out of county to being able to say, hey, let's slow the brakes. Let's being able to talk about that. And there was some hostility, but is that I was able to get information from CPS, psychologicals. There was even a determination of IDD that was only 2 weeks old. 2 weeks old. 2 weeks old. And what we are, and so the defense attorney didn't have that. The probation department in the county didn't have that, and nor did the state. But there had worked out a deal to being able to talk about that. And so some of the things that I was talking about is like, hey, as a defense attorney, what's our number one job? I look at it is to being able to tell that child's story. And we can't tell that story if we don't know that story, and being able to do it. And so while I have the microphone, I want to being able to say, it's like, what would you do if you were on the bench and, you have an attorney running in? It's like, hey, judge, let's slow this process down. Let's not do this adjudication. You're the prosecutor. What are you going to do? The probation department. What are we going to do? It's all about the information, because I started thinking is like, hey, did somebody do an assessment? Did somebody look at their school records? Did somebody look at those CPS records? CPS had them. Did juvenile probation have them? This, unfortunately, is a common problem that I have, particularly dealing with dual status youth, and who it just seems like now, I don't know, it seems like to me, boy, they move around so much, and you have departments that are really trying to being able to work with them. And so I don't know, thoughts, questions, concerns, what would you do if you got some lawyer walking into your courtroom saying, hey, let's slow this down? Well,
I'm getting my mic turned on. We're getting this mic turned on. There it is.
there we go.
For me as a prosecutor, is this a felony case?
Misdemeanor assault.
Misdemeanor assault. So as a prosecutor, when the defense lawyer comes and tells me some of these things, this kid's got a CPS history, this kid's got a mental health diagnosis. Well, you know who's going to be able to confirm those things? The local school district and the local child welfare agency. And all I have to do is pick up the phone and call. School districts, not all of them, but many of them with a phone call can answer some of these questions. Sometimes you have to have a subpoena and get them there. But I know I need more information. Because at the end of the day, what I want is I want this assault to not happen again. Which means I need the best information so we can do the right thing to see that an assault like this doesn't happen again. So like in Tarrant County, we have an embedded child welfare person with the juvenile department. And so if this were a Tarrant County case, my first phone call would be to that person saying, hey, this defense lawyer tells me that John Doe has a CPS history. Is that true? If so, what is it? What is it a situation in which there are findings of abuse with this child as the victim within that family? Who did it? Is that person the victim of this assault? Which is going to maybe tie into my fact pattern in a minute. But those are the things that I want to know. And if there's an IDD diagnosis, I'm going to ask the defense lawyer, can I see it? Some defense lawyers won't hand it over. And that's too bad, because if I can't confirm it, I can't do as much with it. But often, yes?
What is the justification for not handing over the psychological report that would be of benefit to their client?
Because there may very well be some things in that psychological report that I could use against that kid if I chose to. Oh, she said, why would a defense attorney maybe not turn that report over to the prosecutor? And that's because that kid may have made some admissions in that report. So maybe this is a murder case, and that kid is young and has made an admission to their psychologist about the offense itself. The defense lawyer may never want to hand that to me, even though it may otherwise have information to be beneficial to his client or her client.
Would it be acceptable to submit a redacted copy?
Sure,
What you're looking for is the identification by licensed credentialed
sure.
professional.
That's a great question, and I'll just tell you, I'll give you the postscript. 2 reasons. One, the defense attorney may not have the information because they did not bother to ask for that information or those records from the CPS. And in this case, the child was in CPS custody, so that would have been the first thing that I would have been asking for. I did turn it over to the prosecutor and the defense attorney and the probation department. But when I talked to the prosecutor, the first thing I said was, let's have an agreement that this is pre-trial. I want you to be able to take a look at it. And the prosecutor did take a look at it and, gave them additional records, and, happy to say that they ended up, it's like, you know what, we're dismissing this case and we're going to be able to move on. Yes. I would, but however, I have a policy. Is before that I always get into the mental health, but I really don't like actually following through on any of my clients to go chapter 55. When I say that, I don't want them to be committed for an indeterminate period of time, which that is frightening to me. I want them to be able to get the services, and I want them to be able to get services they need in their community. I don't want them to be detained. I don't want them to be taken out of the home. And so I work really, really hard, and it becomes a collaborative effort. That's why I'm a big proponent of a lot of these courts that have mental health courts, or, what we call crossover courts and things of that nature. And so we have a more collaborative process.
And if it can be safely done so, I want kids to get services in the home. There are times, particularly in mental health arenas where a child is currently violent, where that may not be the best option.
Mm-hmm.
But But it oftentimes is a very good option, and there have been many times when I've agreed to it.
Yes. Why don't you talk about your second case?
Okay, well, this may or may not be a real situation, or parts of it. We have 5 minutes left. So I'm going to give you a fact pattern, and before I give it, so the offense is aggravated assault, and an aggravated assault committed by a person who was 16. And when I give you the fact pattern, this person did do the thing.
Allegedly.
Well, I'm saying that this person also believes that she did the thing. But that's not really the point. The point is this. So on an aggravated assault at age 16, I actually have 3 avenues I can go down, and I've gone down all of them. I could seek to have that 16-year-old certified to stand trial as an adult because she's old enough. And I've done that. I've not done that on an ag assault case, but I've sought certification against many children over the years. I could also seek a determinate sentence where she could get up to 20 years in prison, 20 years in TJJD with a possible transfer to the adult prison to finish up the sentence. And I've sought those sentences. So the third door is to keep the child in the juvenile justice system, and those 2 options are probation or an indeterminate commitment to TJJD. So I've gone down all of those roads. So when I get a case like this, I have to, when I'm first reading it, be open to this is the entire range of things that I could seek, and I need to place this child in this offense somewhere on that continuum, and that takes a lot of data. So in this particular instance, we got a 16-year-old. Police get called. She's gotten into an argument with her mama. During that argument, her brother jumps in and says, "You can't talk to my mama that way," and 16-year-old grabs a box cutter and goes after her brother. She didn't get him. He grabs it, takes it away from her. She then runs in the kitchen, grabs a couple of knives, and runs after mom. Well, they disarm her from that too. No one gets stabbed. But those are classic aggravated assault with a deadly weapon. You could even call it attempted murder. You could. That kid is arrested. I want you to think about it. A child gets into an argument with mom, and the first thing she does is attacks her brother with a weapon. The next thing she does is she goes and gets different weapons to go after mom. Do you think this is the first time there's been a problem in that home? And I don't either. So that tells me, and also, does that sound like an otherwise, there's no such thing as a normal teenager. And my teenager's now an adult too, like Cam's kids. And by gum, those junior high years, my God. But does that sound like a child who might also have mental health issues? Maybe. Sure could be. So the first thing that I did was called our CPS liaison. Do you have any information about this child or this child's family? And what do you think the answer was? Yeah. Would you be surprised to learn that there was a finding of abuse, mom on daughter? No, wouldn't be surprised at all. Do you think it would make a difference to me as a prosecutor to know that and deciding where on the continuum this child goes? Do you think it would matter to me as a prosecutor to find out that mom, when she get mad at daughter, would just go dump her somewhere in public and make her find her way home? Do you think that might be one of those ACEs that we've been talking about? Should I be considering that when deciding where on the continuum I need to approach this case? Would it surprise you to know that this child had been punished by mama by taking things and scraping the inside of her mouth so there was no external wounds? I mean, so there's a lot, and I learned these things because I made a phone call. Thank you. Also learned additional mental health information about this specific child and the mental health issues within her home by calling MHMR. And so with that information, I'm able to make an informed decision of where on the continuum this case goes. In this particular instance, the choice was made to not prosecute the case at all, choice was made that based on the dynamics within that home, the best place for this child, at least in the short term, was foster care. The child was willing to go, and that's what CPS felt was the best route to get this child, get the home stabilized, and get services in place to get that child returned in a more stable situation. So ultimately, that child didn't get prosecuted at all. And I'm not telling you that this was the ideal resolution, but it's, in one particular case, this is the direction we went, and it's all because it didn't immediately jump to, my gosh, you've pulled an off on your mother and your brother, and I've got to lock you up. So
you.
we've been told we're out of time. Thank you all very
I
much.
could listen to these two for many hours. Wisdom beyond their years. Thank you so much.